No crime. Still arrested? Imagine, tomorrow morning, the police knock on your door. You ask, "What did I do?" The officer replies, "Nothing. But we believe you might." Can they arrest you before you've committed a crime? Believe it or not, in India, the answer is sometimes yes. Ordinary arrest. Police catch you. Crime already happened. Simple. Now change everything. Preventive detention. Government says, "We aren't punishing you. We're stopping something before it happens." Sounds crazy? Actually, many countries have similar preventive laws in different contexts, India included. Imagine intelligence agencies receive information that tomorrow someone plans to bomb a railway station. No bomb has exploded yet. No one has died. No crime has actually taken place. Should the police wait until tomorrow? Or should they stop the person today? This is the idea behind preventive detention. Instead of punishing a past crime, the state acts to prevent an anticipated threat. Wait, isn't India a democracy? Why would our constitution allow something like this? Because the constitution tries to balance two values: freedom, security. Imagine a city. Would you rather a government that arrests everyone, just in case? Or a government that waits until a terrorist attack actually happens? Neither extreme works. The Constitution accepted that in exceptional situations, preventing a serious threat may be necessary. That's why it permits preventive detention, but surrounds it with safeguards. This is one of the biggest compromises made by the Constitution. Normally, when police arrest someone, the Constitution gives important protections. The person has the right to know the grounds of arrest, to consult and be defended by a lawyer, to be produced before a magistrate within 24 hours. These protections are found in Article 22(1) and 22(2). But then comes something surprising. The Constitution itself says that these particular protections do not automatically apply to preventive detention. That doesn't mean there are no safeguards. It means different safeguards apply. This is why preventive detention is often described as an exception within Article 22. The government cannot simply say, "We don't like you," and lock you up. The law requires a legal basis. There must be reasons connected to objectives laid down in the relevant preventive detention law, such as protecting national security, public order, or other specified interests. The detention is meant to prevent a perceived future threat, not to punish disagreement or ordinary criticism. Here's another question. If the government itself decides to detain someone, who checks the government? The Constitution provides for an advisory board. Think of it as an independent review mechanism, typically involving people qualified to be judges. Its job is to examine whether there is sufficient cause to continue the detention. If it concludes there isn't enough basis, the detention generally cannot continue under the law. This creates a check, even though the process is different from an ordinary criminal trial. Imagine this. If preventive detention had no time limit, someone could remain detained forever without trial. That would be deeply problematic. So the Constitution says Parliament may prescribe the maximum period for preventive detention under law. Different preventive detention laws may specify different limits and procedures. The key idea is that preventive detention is not intended to become an indefinite substitute for a criminal conviction. Suppose you're detained. Should the government simply say, "Trust us"? No. The detaining authority is generally required to communicate the grounds of detention to the person, so they understand why they have been detained. However, there is an important qualification. If revealing certain facts would be against the public interest, for example, if disclosure could expose sensitive intelligence sources or seriously affect national security, those particular details may be withheld. This is one of the most debated aspects of preventive detention. Can you challenge it? Yes. Preventive detention is not beyond judicial scrutiny. A detainee can approach the courts. Courts generally examine questions such as, was the law followed? Was the detention authorized according to legal procedure? Were constitutional and statutory safeguards respected? Was the detention based on relevant material rather than arbitrary reasons? Courts usually do not replace the executive security assessment with their own, but they can intervene when legal requirements have not been met. Why governments defend it? Terrorism, organized crime, riots, smuggling, national security. Why critics oppose it? Wrong intelligence, misuse, civil liberties, lack of ordinary criminal trial at the outset. Imagine intelligence agencies receive credible information. A person plans to carry out a major attack tomorrow. There isn't enough evidence yet to secure a criminal conviction. If the police wait, hundreds of innocent people could die. If they arrest first, An innocent person's liberty may be restricted. Which mistake is worse? Arresting one innocent person, or failing to stop an attack? There is no easy answer. That is exactly why preventive detention remains one of the most debated powers in a constitutional democracy. Opinion matters.